Excellent. Well, thank you so much for having us here today. So great to be with you. And the title and description were all written back in BC before COVID. Way back when. And so we have some changes for you today, but we'll get to that in a bit. Just a bit more about WCET, and we're part of WCET, the Western State Commission for Higher Education, and that serves the Western states, but our organization was started back in 1989 to look at distance ed technology issues, and was started focusing on the West. And for the first meeting that we had, that Phil Moss and several people from the Regent's office from Oklahoma came and said, hey, we want to be part of this too. And that they came in. So I have a special spot in my heart for our Oklahoma friends, because now we have, we figured out a way to get them in, and we now have members in all 50 states and a few in Canada as well. And so thank you, Oklahoma. With that, for no extra charge today, you do have Cheryl Dowd. Cheryl, I'm going to have you introduce yourself here.
Well, thank you, Russ. And so within WCET, we're about 9 years ago, Russ and his colleagues created the State Authorization Network on the because of what had just occurred in terms of federal regulations around state authorization of distance education, to address that. And institutions were in need of assistance. Some states were looking for guidance. And so the State Authorization Network was born. And I came to the group about 5 years ago as the director. And so we have about 740 institutions that are part of our network now, and we're a collaboration. We share our best practices, and we provide resources and research, for our membership. And we'll talk a little bit more about what SAN does, and we'll give you the link to be able to see our website to see what kind of benefits and resources might be helpful for you.
Excellent. And I'm Russ Poulin. As mentioned, I'm Executive Director of WCET. I've been here for a while, and you see over my shoulder Luna, our favorite cat, which is she's much smaller than the picture indicates behind me. With that, for our agenda today, that we're going to go through some different things, that there are several regulations coming in and going out at different times, and we'll talk just a little bit about that. And then we'll talk about, we'll start off with what everybody's thinking about and having to work on right now, is with what's going on with the COVID-19 and some changes in those regulations. And then there are some regulations that are coming in July 1st-ish or around there. We'll do that, and then we'll split those up into two groups. And then there are also some future regulations, as you see there, with that we'll be getting to, especially the regular and substantive interaction. And what we want to do is that there's, I think, like 4 times in here where we're going to stop for questions, because we know that these get complicated. So we want to stop, and then we'll take some questions, and then move on maybe after a few of those. With that, let's get rolling. So the very first thing that we have here is that there is confusion around, and we are talking about federal regulations on all of this, although we will refer to state regulations at time, and accreditors at times, as they all kind of come in together. But we're in this time period where there are regulations that are in place at this time, and that you're expected to be following. But then through the Department of Education had something called negotiated rulemaking last year, that they came up with several regulations, and that the first ones that they released are around state authorization and changes to accreditation, and that those go into effect July 1st, and a few of those could have gone into effect or did go into effect prior to that. But July 1st is really where we're looking at. And then there's another set of regulations around regular and substantive interaction that have not been released yet. And so we'll talk briefly about those at the end, because you need to know about it, but we really don't have a schedule for when those will come out, and current events have probably made that even more confusing at this point. On top of that, we have everything that's happened around COVID-19, and that, that nicely that Department of Education and others have been reacting and trying to figure out, where are places where we can allow for some leeway, provide waivers or some changes to regulations. And so I have March 5th up there in terms of that there was some of the first guidance from the Department of Education came out that day. Some of the guidance and some of the different things give different dates, but to be sure, I think that they'll continue to extend it as long as it's a problem. And so I have the question marks at the end. So you can see it's likely that some of these waivers can go past new regulations coming in, and who knows, into the future. And so so sometimes the question or the answer to a question depends on what time period that we're talking about or which waivers are in place. And so please bear with us, and we'll try our best to answer around that, but needed you to know about we understand why it can be confusing with all these different things in play at this point. We are going to move to this first section, talking about what is going on with COVID-19, and then get to several of the things that that are out there at this point. In some of them had to do with so an accrediting agency is supposed to have approved an institution to offer distance education before it can offer distance education at any scale with that. And so so there's been a kind of a waiver, or at least a change, so that if some accrediting agencies have done this differently. So if you don't already have distance ed approval, and I imagine most of you probably already do, that they've done some virtual approval processes, or some accrediting agencies have just said, you're good to go for now, we'll catch up with you later. Back to the issue of regular and substantive interaction, that they are still expecting that there be, and I put these words in here, on purpose, that this is what was in the guidance, that they're expecting substantive communication with the students, but they are allowing for a lot of leeway. And in fact, we were talking to people in Virginia yesterday who were doing a lot of things via phone calls, because in rural parts of Virginia that the internet is just not adequate, and so they're figuring out other ways to do that. But regular and substantive interaction is really important, that you pay attention, that you're at least not putting out just correspondence courses with this. Also, and then you see the 3 question marks I have there at the end. I'll use that a couple times here, where there are things that we're still a little confused on. They've gone back and forth in terms of their guidance on this, where the initial information that came out was that, remember that you need to follow all the accessibility rules, but a lot of institutions said that's kind of difficult because we're just throwing stuff online as fast as we can. And then they came out with guidance last week, really aimed at K through 12, that said that accessibility should not be a barrier. So, my advice to you, and that we have, that I believe we have in the resources at the end, we have some advice that we have from an accessibility expert from WebAIM about, we understand you had to do what you do at the start, but be sure that you're doing your best to try to serve all students. And we sort of get into a moral thing beyond just the rules. The accreditation thing is that we don't want to throw a whole generation of people with disabilities off the lifeboat just because we weren't able to get to them. So there's kind of a difference between rules and what you're able to do and when you're able to do it. We know you're doing your best. We understand that it's hard, but do pay attention to those. And accessibility is there. My guess is that from a Department of Ed standpoint, they're probably not going to hold it to you. If you're really egregious on not doing it, I'd worry about lawsuits. That would be the other thing. Some other things in here, and these we don't know as much about, but thought we'd throw in here because these are more direct financial aid things. that you could have temporary federal financial aid consortium agreements, and that means that you can have temporary agreements among institutions that maybe your institution can't quite meet all the distance ed needs that you, or the remote learning needs that you want, and that you working with other institutions, waiving requirements, shortening the academic year, that some institutions are doing that, that can do that up to a point, and that the spring term, typically terms don't overlap for federal financial aid purposes, but there's understanding that there's been delays at some institutions, or they've gone like 2 or 3 weeks without courses while you get prepared to move into the remote learning, and so that you can overlap with the summer term on that, and so that's a bit of a change. And then Cheryl, you want to talk about NASFA?
Sure. NASFA is the organization that is the federal financial aid offices, or actually it's not even just federal, it's financial aid offices at the institutions. It's an organization for them. However, they are providing to the public, to institutions and the rest of us, the opportunity to participate in their webcasts. They have a wonderful website, which is provided here, and this particularly is their COVID-19 resources, where you'll find various documents, access to webcasts, including a webcast that you can still register for that's going to be on Thursday. So you can register for that there. Plus, they have access to their podcasts. And I'm not somebody who knows a lot about podcasts, but I do enjoy NASFA's podcast. It provides a lot of good information, and it's in a lighter atmosphere, so it's really great to absorb their content in that format. And you can get access to all of that from this page here. But I do strongly urge you to review the opportunity for the webcast that will be held on Thursday. It's a follow-up to their, I believe it was March 17 webcast, where they talked a lot about these provisions that Russ just described for you, and may help you with trying to determine how to manage the different modifications that you've been doing at your institutions.
Great.
And moving on to what has happened for our veterans, a very positive note is that Congress moved very quickly to help preserve the GI benefits for students during this COVID-19 issue. What had happened was the federal laws in place were very strict about how the GI Bill benefits could be provided for housing allowance and for appropriations benefits. And so what they found is specific to approvals by for the institution of the programs, there was a strict process that had to be applied. And so with this rapid transformation of modalities, it found that there would be students who would be left without their GI benefits if some modification hadn't occurred. So they had no flexibility in terms of the law the way it was written. So what was needed was a new law in an emergency situation. So what we saw was very quickly, Congress moved within a week's time to prepare and have it signed by the president to have a law in place that will preserve the GI benefits for our veterans. So you'll see that they will be able to receive full GI benefits through this emergency standpoint. Now they have it through December 21st. At this point, but just like as Russ was pointing out about some of the other types of flexibilities and waivers, I think that the government will be assessing, whether there needs to be any extensions or not. But at least for right now, what we see is that this change to modality is not going to impact GI benefits.
Excellent. And then for all of these things that we covered, we're going to go to questions now. Let's see. I think we are. There we are. We're going to go to questions. Yeah.
Well, all I was going to say is to Russ, I was glad that Russ put the URL there for some more information about what was, you see there at the bottom of the page, about the GI benefits, and you can get more details about what transpired.
great. And then in our resources at the back too, and you will get copies of the slides that in the resources at the back too, we refer to policy briefs that we've created on all or most of these things that are what is happening in the accreditors, what is happening with federal regulations, what's happening with the veterans. And we're just we put them up and we haven't really announced them. We're going to announce them this week. So you all get to be the first announcement here that we're doing that. And so Brad, do we have questions?
We did have one question in the chat regarding accessing clickable links, and I'll be sure to send out the copy of the presentation to those on the registration list after the session today so you can access all those resources. Yeah, but any other questions, we can take those in the chat. Let me see the Q&A here.
Q&A had one there, Brad, and I wish I knew the answer to it. It has to do with the pass, no pass affecting the GI Bill benefits. And I don't have an answer to that as it wasn't part of the specific legislation in terms of the language. It doesn't address that specifically. And I'm wondering if that isn't more of a Title IV issue. Russ, do you have any knowledge in that area?
No, I think it might be a GI Bill one for veterans, but they have not. I've not seen them specifically address it, and unfortunately, the Veterans Administration has been has not wanted to. They feel really constrained by the rules as they are, so we'll have to look into that.
But here's the good news about that. I did understand from the Veterans Administration after this came out, they indicated that they were going to be contacting all of the institutions to be able to talk about the appropriate implementation. So I do feel like there's going to be more guidance from the VA on this. So you can be looking for that because they did address that very specifically, that they would want to be providing that to institutions.
Yeah, and we're gathering things like this that we can get more guidance on. And so those are good questions to raise, and that we'll put that one down as well.
Great. And
we have somebody raising their hand.
Kyle in the chat window here. Kyle, again, is the Assistant Vice Chancellor at the Oklahoma State Regents, and he was told by our state accrediting agency that the no pass grade should be fine with the VA. He doesn't speak for the VA, so he can't say 100%, but that's what he was told.
Sure.
Yeah, and that is that there's the state approval agencies for veterans benefits in each state, and that those are good people to get to know and to ask these questions because they're staying on top of it.
All right, I think that's all the questions for the moment.
Okay.
Great. Okay, we'll move on to the next section. Okay, so Cheryl, back to you with state authorization and professional licensure.
Well, this was 2019 was a very busy year. You may have noticed from Russ's initial title. Actually, Russ, can you go back just to the title page for a second? I just want to point out going into effect, I meant the one for the section, sorry, about it being having to do with July 1 or earlier. I just wanted to stress that effect July 1 or earlier because the state authorization regulations, you can go on to the next one. I just wanted to underscore that. What Russ is talking about that in that title slide is that that is the effective date for new state authorization regulations that came out November 1st. But what's interesting about that is in that set of regulations, it was identified by the Secretary of the Department of Education that she could provide that certain regulations could be subject to early implementation by the institution. So it's an institution choice to early implement. And the reason for that was because there are state authorization regulations that are currently effective. We call them the 2016 regulations because they were released in final form in December of 2016. But there was a lot of drama that went along with that in terms of their effective date and a delay and a lawsuit. But ultimately, in May of last year, 2019, the 2016 regulations became effective due to a court ruling from the U.S. District Court. So my point in telling you that is that 2016 regulations around state authorization currently exist and will be effective until the new regulations take their place. And so the 4 different areas we'll start with here. First is the federal regulation around state authorization. And what it does is it ties state compliance to the ability to participate in federal financial aid. So it's about state compliance to be able to participate. And approval in this state compliance either can be directly from state to state or through a reciprocity agreement. You might remember prior to there being reciprocity agreements, institutions were going to have to go state by state to be able to obtain approvals for institutional approval. But then when reciprocity came on the scene a few years ago, that was another alternative for institutional approval. So what this does is it's indicating that for the purposes of state authorization for federal compliance, you can be either compliant by a state or through participation in the reciprocity agreement, which we'll talk about more in a minute. But what's different in this 2019 set of regulations is that the focus is on student location. The 2016 regulations continued to use the word residence, which we were sharing that we had a concern about because residence can be taken in a number of different ways. Example, the student could be a military student who lives in one state to participate in the activity of the institution. The institution's in another state, and yet they're a resident for purposes of taxes and voting and driver's license in yet another state. Because states look at the location in terms of having approval of the activity. So it's the location of the student is what's different in this 2019 set of regulations. And it's the location at time of enrollment, or if the institution receives a formal receipt of notification that there's been a location change. And the preamble of the regulations talks about there being some sort of format at the institution where they're receiving a change. For example, if a student's going to participate in an out-of-state experiential learning activity, or at a registration time period where they've asked for location. So those could be examples of the receipt of notification of a student's change of state. Can we move to the next slide, please? And I talked a minute ago about a state authorization reciprocity agreement. Many of you on this call may be familiar with SARA, but we're not talking about the entity here. We're talking about a definition of reciprocity. So we do have the entity SARA that we're all familiar with, but this is a definition of reciprocity. And it was defined as an agreement between 2 or more states that they will follow the agreement in order to provide approval for distance education. And very specifically, they indicated that the state may enforce general purpose laws that apply to any business. So that could be things like Department of Labor could have requirements over any business. The Secretary of State may have registration requirements, but this is not about an approval step for distance education. That would be outside of a general purpose law. So we're talking about here is the opportunity for an institution to have approvals by participating in a reciprocity agreement. Could we move to the next slide, please? Okay, so here are this is what many people have questions about. So in the current 2016 regulations was a regulation 34 CFR 668.50, which you see a line through it, because that was removed. And what that regulation indicated was that there were to be certain disclosures that were specific to distance education. But what they found out was that in reviewing those regulations, most of them were already provided in the Code of Federal Regulations for all modalities. So it was redundant to keep this regulation. What was missing was professional licensure disclosures. So they added that into 34 CFR 668.43. So what they're requiring here is that institutions will provide disclosures for professional licensure, and it's regardless of modality. So we moved from, in the 2016 regulations, only requiring professional licensure disclosures for distance education, and now these new regulations open it up to be requiring disclosures for all modalities, so face-to-face and distance education. So I want to describe what types of programs we're talking about. We're talking about the programs that are designed to meet educational requirements that are required for employment in an occupation, or are advertised to meet professional licensure requirements for a state for occupation. So people often ask me, well, would this apply to this program that provides that kind of opportunity for students? And what I always share with institutions is that it's a really positive step to read through the regulation in its entirety. You can break it down into its components, much like I just shared there about what is designed or advertised, you know, in terms of meeting state requirements for an occupation. So I do urge you to review that. So when we talk about this first part, why do we require this, or why is this going to be required for institutions to do? And we talk about transparency, because we want to be able to provide students with the opportunity to know whether their education is going to provide them with the opportunity to sit for licensure in the state that they wish it to. So when we see this first part, A, that has to do with general disclosures, and we can move to the next slide, please. So when we talk about general disclosures, we're talking about something that's public facing. So what we see here is that the requirement is that the institution will provide the list of states where the curriculum meets the educational requirements in a state, a list of states where the curriculum does not meet the state educational requirements in a state, or the last one, that the institution has not made a determination whether the curriculum will meet state educational requirements. So it's going to be the responsibility of the institution to look nationally and identify in which states fit those three categories, and provide that in a public-facing manner for the students when they're reviewing your institution. So it's to provide that forward-facing to institutions. Now, what I will share with you is that the department indicated in the preamble that an institution could be compliant tomorrow by making the final aspect that they have not made a determination whether curriculum meets state educational requirements. That is an option. However, I would also like to point out that the preamble indicated that that they expect the institutions to systematically move through their programs to determine ultimately whether they do or do not meet educational requirements. But it is satisfactory to indicate that there hasn't been a determination made. And that's for the general disclosures. But here's the thing. If your institution does not meet state educational requirements or has not made a determination, and we'll go to the next slide, ties together, then you're going to be providing a direct notice to prospective and enrolled students. So I just indicated you're going to be looking nationally about your programs, and then this is specific to students, providing a direct notice to prospective and enrolled students. Well, which prospective students? So we're talking about here is students prior to enrollment in the program, and the ed guidance that was provided in the preamble is before there is a financial transaction. So we're talking about providing a prospective student prior to enrollment in the program if the notice that your program does not meet the state requirements, state educational requirements, or your institution has not made a determination before a financial transaction has occurred. So, you know, we have a question mark there. You'll notice if you read through the regs that they're indicating, the department's indicating that you'll be providing what your process is for determining location of the student. So I would urge you, not only are you documenting the how you're determining location, but actually how you're determining location prior to enrollment in the program. So you can show the department, if asked, how you determined which students you're providing this prospective student disclosure. If you have students that are already enrolled, you will owe them a direct notice if the curriculum no longer meets state educational requirements. If the institution has determined that, if it's come upon that information, and if the institution has come to that conclusion, then they have 14 calendar days of making that determination to share that notification with the students.
And Cheryl, that there's been some confusion from some institutions that they're thinking that, oh, well, we'll wait till the student comes to campus and then we'll notify them about, so you're in Ohio, that's Ohio State University, they'll say, we'll notify them about Ohio, but that's really, really too late if they're coming to a face-to-face. Is that right?
Well, what we have here is before a financial transaction. And so, you know, if that would be too late if they're going to be enrolled in the program already and they've already provided some sort of financial transaction. So what's going to be important here, and I appreciate that Russ has brought that up, is that the institution develop that policy of how they're determining when is enrollment in the program. Because some students, and I think it's more clear in this generation that they are enrolling in the program when they start at the institution. What may be a question mark is if they're enrolled in a program after they have become a student and then apply to the program and are then enrolled in the program, because some institutions require a certain amount of gen eds before they can even enroll in a program. So it's going to vary, but as Diana or Jones, the Assistant Secretary, Department of Education, has shared that she expects that location will be determined differently at institutions. So she is expecting to see that there will be documentation of how an institution is determining how they're coming to location to provide approval and to provide notification. So we will see that moving forward.
Okay. Let's go to questions.
All right, we have one person that's raised their hand, Dominic Christensen, I see. I'm gonna push the button to allow you to talk. You might have to unmute yourself there. All right, and while we're waiting on that one, we do have a question in the chat box actually. Is there any nationwide federal program or project for course equivalencies for students moving from one institution to another across state boundaries, particularly for online courses or otherwise? And just a little background, Oklahoma does have a course equivalency project program in place for institutions across the state. This is in reference to transfer credits.
I'm aware of this in other states as well. As far as a national course equivalency.
But let me try that, Cheryl.
Yeah,
I was
going to ask you to do that.
Yeah, I think there's some programs. I know within WCET that they have a program that is not limited to WCET institutions or WCET states, but they have something called the Interstate Passport. And what they have done is that they've created it where, at least at the gen ed level, that it's focused more on competencies than actual courses. And so that if you can attest that your set of courses meet the agreed upon set of competencies, then the whole gen ed is transferable. And I think they're looking to expand that to other sorts of things. But I know that that's a big one. I know that there are others working on this, but it is really, problematic to try to get transfer is something that's held very closely by the institutions and registrars and faculty. So it is a difficult topic.
Yes, and we've actually worked on this in our agency as well across Oklahoma, looking at as well at how we could incorporate prior learning assessment, AP scores into that kind of an analysis too. It's a very complex project to get into because, as you mentioned, all of these different institutions handle things differently, store data differently. But that is definitely a strategic goal for the state as a whole, is to make it easier to do those transfer evaluations.
Yeah, you see a lot of in-state sort of things that have done well. And a lot of those are legislatively mandated too. So.
Right. All right. Any other questions before we move forward? Watching the chat box and the Q&A feel free to raise your hand.
The only thing that I would share, before we move on is that that institutions may want to review the specific language of this regulation, some of these sets of regulations, these 3 main regulations, because I have questions from folks about, well, do you think that they'll postpone the effective date of this regulation or these regulations? And, we may see the flexibility waiver aspect impacting them. But the good that it does is substituting for the 2016 regulations, which had difficulty in their language to be able to implement. So the 2019 regulations are more clear than the 2016 regulations that they're being substituted for. So moving forward with them makes more sense. But we may see some waiver and flexibility aspects around them, as Russ indicated, if we see that extended.
We did have another question come through in the Q&A. Do disclosure agreements need to be on a public website, or can they be held locally and provided upon request?
This is a question I would talk with your financial aid office about, because they're going to be familiar with how 668.43 institutional information is generally provided and deemed accessible. I mean, not only accessible, but acceptable in terms of a review of your institution's work. But it's supposed to be generally available in the language of the 668.43 regulation. But I think best practices may be something that the financial aid office can provide them. We've been saying all along that this is a good opportunity to collaborate with the financial aid office, since they're familiar with this regulation.
Yeah, and in general disclosures typically are found on the web, it seems to me, and get that. And then remember that the direct disclosures, that once you're getting to the point where the student's going to have a financial transaction, so you think they're going to apply, you think they're going to pay something, that then you have to send them something in writing. There's no hiding it at that point.
All right.
Are we good?
That's all I'm seeing for the moment.
Okay. Right. Here we go. Let's see, let's go into some other ones that are coming up July 1st around accreditation issues. And this is one, I should have put the little red question marks by this one because I've had different people say different things about it, but essentially that they've ended the distinction between regional and national accrediting agencies, and that everything, it now divides accrediting agencies into 2, either institutional accrediting agencies, which would lump in all the regional and national accrediting agencies, and then programmatic accreditation in things such as business or engineering or nursing, so that those would be the only distinctions. We have heard different things in terms of interpretations of that, where I've heard some regional accreditors say that they don't see where it's really going to change what they're doing, but they're allowed to remain regional should they want to. It's just that they're eliminating the distinction. There has been some talk from the Department of Education that they would frown upon that if an institution were to let's go back to transfer or something like that, that they would only that the only reason that you weren't accepting transfer from an institution was because they were a formally nationally accredited institution, that they would frown on that. Now, they've gone back, so don't take that to the bank. They've gone back and forth on that. We're still following that whole issue. And I think that both the creditors and the department have had other things to deal with lately other than clarifying this more. But I think there's kind of a difference of agreement with that. But it's something to keep in the back of your mind in terms of something that may have an impact farther on. But again, transfer is up to the institution. They just have to make sure that they have things beyond. I would recommend that you have things beyond just that it's a national accrediting agency to deny transfer. So that's one that's out there. Student identity, and this is sort of the student identity verification, the regulation that we're all used to in terms of proctoring and combating cheating, that in the past that we will remember that there were what were considered examples in there about that you could have a login, or that you could actually do proctoring, or there was, I think, a third thing that was, or some electronic method for assuring that the student who registered for the course is the same one who was taking the assessment. We're all, happy about, we want to make sure students are, valid students and that they're not cheating on these. And so they did remove those examples because what they were seeing were a lot of institutions that just said, oh, we have a login, it must be great. And students aren't cheating because we have a login. And so they felt that that was a problem. And what we were seeing, and we saw this as a theme throughout the changes in regulations, that there's much more reliance on accreditors for all of this, and that there's interest in terms of, this may actually make it a little tougher for you in the future in terms of, you must actually have, what are the reasons that you're using the products here? Why are you using face-to-face proctoring, if we ever go back to that? Why are you using the assessment methods that you're using? Why are you using this? And is it actually curbing the cheating that could be going on? I have to tell you, so I sat on the subcommittee that worked on this, and we tried to get this so that it would be, this would be applied not just to distance ed, but to all modalities. And that got struck down. So sorry that we weren't able to get that to you, because we think cheating's bad wherever you are. And there's all sorts of technologies used in large courses that we know about, or small courses that things are happening. And then made sure with my graphic there to show, if you haven't been to that writer1.com thing, that you can go and you can buy all sorts of essays, and it's perfectly legal according to them, which it is not. Well, I guess it's legal. Some states it's illegal. It's just not. I'm hoping colleges in Oklahoma, as elsewhere, frown on those. So this is something. The other thing about this one is that I've seen a couple proctoring companies, of the online proctoring companies, misstate what is required here, that they make it sound like you have to go and buy one of their services for distance ed, that that is hyperbole, that they're using that as marketing speak. So don't get caught up in that language, and that they don't even use the right language, because they say, due to the change in the Higher Education Act. Well, there hasn't been a change in the Higher Education Act since 2008. This is something completely different. And so when you see that, don't get fooled by people trying to take you down the garden path to make you try to buy their product. And so one other thing that I think is really, it could be really good, and that we're working on, that we were really trying to help out with competency-based education, with some of the rules that come out, and we'll talk about regulating substantive interaction in a moment. And there's some other rules that are coming out around direct assessment, which is another form of financial aid that we made the rules easier on that, so that I think we had, under the former direct assessment rules, it was a form of aid that competency-based education and others could use, but I think we were up to 7 institutions in the entire US that were using it, because the rules were so complex and hard that we tried to make those a little bit easier. So we're hoping that will help. But another thing that they put in there was allowing for the thing. Well, let's see. The thing that we know for sure, looking forward in the next 10 years, is that there's some innovation out there that we can't even imagine what it is right now. Right? That you think that mobile phones are only been big for the last 10 or 12 years. That we need more flexibility even in the regulations, and that there is some ability under certain conditions where we're making sure that students are held harmless, so that accrediting agencies can do a little bit more in terms of being flexible, in terms of working directly with institutions. Now, that's in there. How that will actually play out, and how the Department of Ed will receive that, and how the accreditors will react, is still a bit unclear. That not really seen an accrediting agency address this very directly, but at least it's out there and it's something to be aware of. And as we get into new things, that it may be an alternative for us to be looking at. Again, I'm all for protecting students, but which is primary importance in all this, but also figuring out we don't want to protect them so much that we don't allow them to learn in new and more effective ways. So with that, on those three things, just seeing if there's questions that anyone has.
Not seeing anything currently in the chat window or Q&A.
Excellent. Okay. We'll move on. So there's another set of regulations that that came out of that same negotiated rulemaking that have not yet been released for public comment. And that's the process, is that they're released exactly since the rulemakers came to consensus. They all agreed on the language. That means the Department of Education has to put them out exactly as was agreed upon in that process. For a certain set of regulations, that has not happened yet. And so we thought they were going to come out in November. It seems like it's past November now. And then they got caught up in Title IX regulations and working on those around gender and equity around those. And we're hoping that those will come out. Well, I know they were going to come out with those soon, but they may delay it because of the COVID. And these are probably delayed as well. And the biggest one for our audience is on regular and substantive interaction. So we know what the language says that'll be released, and we can talk a bit about that. And then we'll see what that will be. But as of now, the current understanding is what we want. The problem with the current understanding is that you need to take the whole notion of interaction and what you think is good interaction in a classroom and students talking to each other and back and forth with faculty, and put that aside and go with us in terms of what they're interpreting interaction for the purposes of policy, the Department of Education policy at this point. And at the bottom there, I have guidance is incomplete. And it's really true that they have provided some guidance, but what has happened is that then it's been applied differently when they've gone to do audits of colleges. And one will probably remember that Western Governors University had a $700 million, which has really ended up being over $1 billion finding against them for not following these rules. And we'll talk a bit more about that. And so one of the things, so Van Davis, who's now contracted with us, used to be at Blackboard and used to be with the Texas Higher Education Coordinating Board, and I, back in 2016, we said, okay, this is a little nuts that institutions don't know what criteria that they're being held to at this point. And so we did this blog post and said, okay, we looked through what is the guidance that is out there and what are the findings that have been found that auditors have done against institutions on them, and what are they looking at, and came up with these four things. This blog post, oddly enough, since we published it, has been the #1 blog post on WCET's Frontiers blog, most read blog since we published it every year, because it seems to be the place where you can find at least the clearest information about this. Why it's not the Department of Education and not us, I don't know, but there you have it. But first of all, the crazy thing is that interaction must be initiated by the instructor. And so interaction where the student initiates it, that doesn't count, or by anyone else, or student-to-student interaction. None of that counts. So it's all initiated by the instructor. Regular and somewhat frequent, they're really big on what does the syllabus say. Syllabus says that you're going to send things out on Mondays, or you're going to have a test every so often, that they're really big on that, that you have some sort of plan for it. Substantive, that this seems to be one that would seem to be the easiest one, that it's not talking about the Oklahoma State football or basketball game. Should we have those again? But it's talking about, if we're class about Chaucer or Shakespeare or something like that, they were actually talking about literature in it. And with an instructor who meets accrediting agency standards, that seemed clear to us at the time that it was up to the relationship between the accreditor and the institution. The problem is that the WGU audit came out after that, and their accrediting agency had approved the instructor model that they were using, and the Office of Inspector General for the Department of Education decided to overrule that and said they didn't like the instructor model that was being used, and so that even when we wrote that they kind of went around that. If you don't know, for the WGU thing, that what happened is that the ultimate finding was from the Secretary of Education and her staff was that indeed that there were several things that were unclear and that they felt WGU couldn't be held to. There were some things where they were not in compliance, and I think the ultimate fine ended up being like $50,000 or something like that, much smaller sort of thing out of all that. With that, let's look at the so in this here, I'm looking at several different columns, several different items, the ones that I was looking at before, and then I have summarized in the before 2019, and then in the right-hand column, I'm going to have what the 2019 and what we're calling the 2019 regulations, what came out then, and the ones that will come out someday, what they'll look like. And so the changes will be, so interaction only initiated by the instructor before, even though that wasn't anywhere in the language, that in the new regulations that we try to provide a bit more leeway with that, and it seems like it tried to get away from it being just from the instructor in certain cases with that. The instructor meets accreditation standards. With that, I have the little asterisk there because we had the WGU anomaly in there where they said they didn't meet that, and we've gone to in the new rules seem much more explicit about that you're relying on the accreditor approval, that accreditor alliance, because we were aware of the WGU thing and tried to make it more explicit that it's the accreditor, again back to the accreditor institution relationship, that they're the ones who really seem to know what's going on. Substantive, that there's a list of activities. This is one I really didn't think we had to mess with, but others on the committee did. And there it has a list of activities, and I should have put the little question marks around that one probably because we have to be, we believe it's the whoever's listed as the instructor or one of the instructors for the course has to be providing instruction or tutoring or assessment, and has these things that they should be doing, and we should be able to comply with that pretty well. The one that's probably the most helpful and problematic at the same time is the whole regular thing. And what we were trying to do is trying to address competency-based education and other sorts of forms of education, adaptive learning and others that are by definition irregular. And what happened is that that word regular is in the actual statutes right now, without Congress changing that we couldn't really change it, but we were trying to work around that and try to give some guidance around it. And so we came up with, this was really hard. I worked on this a long time, and others came up with better language than I did, but we came up with two different paragraphs. One talked about, it kind of reflects what we've seen before, what I talked about before, that it's very predictable. It's sort of the typical online education course where it's over the semester, that you have the syllabus and it goes over 15 weeks and you're going to have courses in it, you follow the syllabus and get that. Then there was a second part where it was more of the irregular sort of courses, and that was that the faculty member is actively involved in tracking the students and figuring out what's going on with them, and then if there's either the faculty person figures out the student needs help and intervenes, or that the student is able to ask for help. And so this is where back to interaction can come from the student, and that gets to count as well. Unfortunately, when it left our committee, it had an or between those two. And when it left the main committee and got approved, it had an and between those two. And that's really problematic for us, because I can go into that longer, but when this comes out, that we're going to argue, and we would like your help in terms of trying to change that back to an or, because we think that it just doesn't work for something like a CBE course to then be tied to, okay, your CBE could be irregular and you go on the student's pace, but you have to meet at regular times, and everything has to be to a regular class. It just doesn't work. So we would like to get that changed. So we'll be looking for that. Again, this hasn't been released. Watch for WCET Frontiers, and we'll be asking for your help for comments on that. With that, questions have come up.
Not seeing anything in the Q&A or the chat box at the moment, but anybody, please feel free to raise your hand or type in the box.
Okay, while they're thinking there, that we'll go through that. We have some resources here from WCET. We mentioned the Frontiers blog, that we do follow a lot of different things, both in policy and in practices. What are good things that people are doing? But you see a lot of things that we've mentioned here. The blog post about regulating substantive interaction, that we have that down there. And as Brad said, that we'll make sure that you get this version of of our slides and things. We have some updates on COVID-19. The second one there said that the policy briefs, where if you want to know, what's the most that we know about what's going on with the veterans thing, that have a short brief on that I think Cheryl wrote, and that we'll be updating. And so I think we're up to 17 or 19 of those, and we're just releasing those this week. So you can go look at them now. And so we just haven't fully announced it at this point. Let's see, and then state authorization network's a great thing. We love Oklahoma to join that. One membership, you can get the whole all the public institutions in through the Regent's office if you want. And so there's some different resources that you see there that you can look at those. And that's where we're at. Any questions yet?
Let's see, we have one coming in. What about student teaching and practicums required for teacher certification? Any changes or relief on that end?
That's a really good question.
Go ahead.
I just wanted to point out that on the SAN website, you can get access to some lists that we have in regard to COVID-19 notices that are from programmatic accreditors, institutional, formerly known as regional accreditors, and also from national associations of state licensing boards. And I just this morning put up one from a national association of state boards, and there were about 7 or 8 states that have provided information about how to manage the student teaching aspects. So you can look there. So this SAN website right here, I believe it's the second item under quick links. That's our homepage that you see there, and underneath that you'll see that there's some links to a variety of resources, and it's public facing, and you'll see several national associations, and you can look there, and teaching's the last one on that list.
Any other questions? I'm not seeing any in the Q&A or chat box right now. All right. I think that's it.
Well, Brad, thank you to you and Bucky for inviting us here today, and you can find us at different places, and we'll answer questions after this. And thank you all for your attention.
Russ and Cheryl, thank you so much for joining us. Your wisdom definitely impacted me at the first WCET conference I attended in November, and I know that this information has been very valuable for our audience. So thank you for your time today.
Thanks for inviting us.
Have a great day, everybody. Stay healthy.
Thank you all. Bye.
Bye-bye.
Bye-bye.